Hello and welcome to Narayana IS. I'm Pratik, faculty for Polity, IR and Security. Students, I hope you're doing good, right? So in the last class, we discussed few topics under the theme Important Acts, Bills and Guidelines. I hope you revised the topics that we discussed yesterday by downloading the notes from the description. Today we'll try to complete the remaining topics under the theme laws, acts and the important guidelines, and if time permits we can also start the topics under the new theme. So today let us start with a new topic, that is Right to Information Act 2005. Now what is the context? A recent report by the NGO, right, has highlighted that governments are weakening the RTI Act. Governments are weakening the RTI Act by delaying the appointment of information commissioners who play a key role in upholding citizens' access to government information. So this is the context, which means the government is delaying the appointment of the information commissioners whose mandate is to provide information to the citizens. This is the context. Now let us try to understand the concept of right to information. What exactly is Right to Information Act of 2005? Now, the RTI Act, it gives every citizen, not everyone who is residing in our country. This right is exclusively given to the citizens of the India, and the citizens of our country have the power to ask. They can ask for any information and receive information from the government. For example, let's say there's a road construction going on. The citizen can ask the amount of money invested in that particular road infrastructure, and the government is obligated to provide information under the RTI Act. And this information, RTI has actually helped people to actively participate in democracy, because one of the important features of democracy is that people should actively participate. People participate in the democratic functioning. So instead of remaining, let's say, passive observers, here people are actively participating in the democratic process. Then it also ensures that it ensures, most importantly, transparency, especially in the functioning of the, let's say, the legislature, the executive, the judiciary, and most importantly, the right to information. It makes the public authorities more and more accountable, answerable. So this is the essence of right to information. That is, here simply the citizens can ask for any info. Of course, there are some exemptions. We'll discuss which are the exemptions. But uh, please, I hope you understood the essence of right to information. Now, talking about the philosophical roots, the background of the right to information. Now, see, the idea of the right to information, right? It goes back to the times of Aristotle, a political philosopher, right? Now, Aristotle believed that liberty and equality, the concept of liberty and equality, are only possible when citizens have full access to how the government performs or work. Then only liberty and equality, it's possible, it's of any meaning. Which means having access to information, it helps individuals, how it shapes their political opinion, let's say social opinion, let's say the economic identity, and most importantly, it actually contributes to a person's growth, personal growth, right? So this is the philosophical background. Now talking about the constitutional recognition. Now when it comes to constitutional recognition in India, the right to information is considered to be a part of fundamental right. Very, very important point for your prelims. A statement can be asked. Fundamental right under Article 19, which is the freedom of speech and expression. This means citizens have the right to speak freely and also know what the government is doing, the functions of the government, how the government is performing. This is a which means right to information has a constitutional backing. Now, talking about the international recognition. Now, when it comes to international recognition, the United Nations, the United Nations recognized this right as early as 1946, post the, sorry, 1946, when the United Nations was formed in the year 1945. Immediately 1 year post that, this right to information was accepted by the United Nations. Now, United Nations states that freedom of information. What? Freedom of Now freedom of information is a basic human right, and it is very, very essential to protect other freedoms. To protect other freedoms, right to information is the basic right. And this right has was strengthened globally. How? Through the International Covenant on Civil and Political Rights. This right to information, was strengthened. How? With the coming of this convention. Now, this convention, this international convention on civil and political rights, it made access to information a legally binding right under Article 19. So, this conception actually nudged many countries to make right to information as a basic right in their country. Now, if I talk about the features, now these are some features. Again, if you want to, it is important that you read each and every feature, because right to information is a very important legislation. So questions are expected from this topic. As the petitioners are arguing that the government is trying to dilute this particular law, it is important to understand the provisions of this particular law. So let us go through the features. Now, when it comes to scope, please remember it covers the central, state and local government bodies, including the ministries, departments and agencies. One very important point. Each and every point is important for examination. Why? Because a question on right to information and the statements can be asked in the examination. So you will have to identify the correct statement associated linked with this right to information. So it applies to bodies substantially funded by the government, including NGOs, which means it is also applicable to the NGOs that actually receives funding from the government substantially. It extends to all the public authorities either established through the constitution or through the legislation, which means constitution, be it a constitutional body or let's say statutory body, or a body which is neither a constitution nor statutory but is financed substantially by the government. All these bodies fall under the ambit of right to information. Public authority obligations now, which means the responsibility of the public authorities. Now requires the public authorities to disclose information proactively. By their own, they have to disclose the information. Mandates proper cataloging, indexing and record maintenance, which means the information that they should maintain should be in a required format, and the information that should be available in the public domain should be available in such a way which should be easy to access. It obliges public authorities to publish information on their websites or other platforms. Why? So as to ensure transparency. This is a mandate that every public authorities have to adhere by. Then constitution of information bodies, very, very important dimension, which means this act, it constitutes central information commissioners at the national level and the state information commissioners at the state level. So each commission is headed by the chief information commissioner supported by other information commissioners. So you have one chief information commissioner and other information commissioners. Now these bodies, which bodies? The information commissioners and the chief information commissioner are tasked with ensuring RTI Act compliance, which means they have to ensure that they are complying by the provisions of the right to information. They have to address the grievances, they have to promote transparency in public authorities. And there are three levels for attaining information. Which are these three levels? Again, very important point for your examination. The public information officer, followed by the first appellate authority, followed by the CIC, Chief Information Commissioner. So there are three levels for attaining information. First you approach the PIO, followed by the first appellate, then CIC. So this point again becomes very, very important for your examination. Now does that mean, okay, right to access, it empowers citizens to request any information accessible to the government as long as it is not exempt under the act. Which are the exemptions? We'll discuss. They have the right, people have the right to know about the public authority decisions, the decisions they take, actions, and the basis of policies and operation. It promotes accountability. Then time limits, the public information officers, right? We discussed three levels: PIO, first appellate authority, and then the CIC. So PIO must provide information within 30 days in the normal cases. But in cases which involves life and personal liberty, information must be provided within 48 hours. And then the first appellate authority must respond within 30 days or 45 days, and the CIC at the state, CIC at the state, we have the State Information Commissioner has no specific time limit but is expected to address as soon as possible. So this period they are very important for your examination. So wherever I emphasize that this point is important, which means the chances that this line statement can be asked in the examination. Now, which are the exemptions? Of course, not each and every information will be made available to the public, which means any information which is concerning the security or strategic interests of a country will not be disclosed. Information likely to endanger someone's life or physical safety, right? Personal information having no public interest. Information related to trade secrets again cannot be disclosed. Exempted information must be disclosed after 20 years except in cases where it concerns national security, which means anything to do with national security, that information is exempt. Exclusion of sensitive. Now when we discuss that all the public authorities come under it, that does not mean these security agencies are brought. No. Intelligence and security agencies, for example, RAW, IB, right? They are exempt. Political parties as public authorities. Now, the CIC rule in 13 states that political parties fulfill the definition of public authorities under RTA and they receive government as they receive the government funds. So, this brought political parties under RTA. Right? So, these are some of the features of right to information. Now, let us try to understand the judicial interpretations on the right to information. First is the state of UP versus Raj Narayan case of 1975. Now, here the Supreme Court held that the citizens have the right to know every public acts done by the public officials and stated that transparency is very important. It's a key part of democracy. Then we discuss the Government of India versus the Cricket Association of Bengal 1995 case. Now here, in this case, the court ruled that the freedom of speech and expression under Article 19 also includes right to receive and share information. under Article 19. Then in the People's Union versus Civil Liberties versus Union of India case 2004, here the court clarified that the right to information is a part of fundamental right under Article 19, which is freedom of speech and expression. So the judgment in this case was reaffirmed by the Supreme Court in the 2004 case. So these are the three judicial interpretations. So please try to remember the case name with respect to right to information. I hope you had understood the first topic, that is right to information. All the important points for the examination we have covered. So make sure you are revising it and remembering it as well. Right? Now this brings us to the next topic, which is the right to education. We understood right to information. Now let us try to understand right to education. Now the next topic, right to education. What is the context? Even though more than a decade has passed since the Right to Education Act 2009 came into force, many state governments continue to undermine its implementation. Here the question is with respect to poor implementation of the Right to Education Act. So let us try to understand the law, what the law says. First and foremost, what is right to education? Now, the right to education, this concept is based on the belief that every child in our country deserves access to education. Why? One, for his personal growth. And if he grows, the society also grows. So for personal growth and betterment of society, every child in our country deserves access to quality education as well. Access to quality education. Next, now talking about right to education. Now this right originally came from directive principle of the state policy, which means this right, yes, it became a fundamental right, but before it became a fundamental right, it was a part of directive principle of state policy, especially under Article 45 of the Indian Constitution. And what Article 45 states? That state, it is the responsibility of the state should aim to provide free and compulsory education to all the children up to the age of 14 years. So DPSP says that it is the responsibility of the state to provide education free and compulsory up to 14 age of 14 years. Then there's another DPSP, which is Article 39, which is Article 39. Now this Article 39, it states that again it is a responsibility of the state to ensure that the children grow in safe and dignified conditions. And here it is important to note that it is a responsibility of the state to ensure that the children of our country have enough opportunities to develop fully. Enough opportunities, sufficient opportunities, which means every child should have the right to access quality education, so that through education he can change his fortune, he or she can change the future. Now, in order to bring this DPSP into force, 86th Constitutional Amendment Act of 2002 was passed by the Indian Parliament. And through the 86th CA, right to education became a fundamental right. Right to education became a fundamental right under Article 21 of the Indian Constitution, which means a provision 21A was introduced into the Indian Constitution. Now, this Article 21A, it legally guarantees free and compulsory for all the children between 6 to 14 years. So, DPSP Article 45, 86 CA 2002, 6 to 14, between 6 to 14, these are the important points that you need to remember. So again, what is Right to Education Act 2009? Now this act was passed to bring Article 21A into effect. Article 21A into effect. It ensures that children between 6 to 14, they get free and compulsory education in any neighborhood school. Now, the right to act also includes important rules. Which are the important rules? One, it is important to set standards for schools so as to ensure quality education, and things are transparent and the institutions are also held accountable. Then, ensuring no child is denied admission for lack of documents, or documents should not become a barrier. Third, banning physical punishment and mental harassment, again especially discrimination on the basis of race, religion, caste, requires trained teachers. And last, mandating 25% reservation for children from disadvantaged groups in private unaided schools. Right now, this provision, now somewhere the provisions have been not implemented properly. For example, even the private schools, they have to reserve 25% seats for the students from the disadvantaged background. But again, you see the rich people, they disguise themselves as poor people in order to enroll their child in these schools. This is how the provisions have been misutilized by let's say the authorities as well as the people of our country. I hope you understood the important rules, the Act, DPSP, Fundamental Right, Article 21A, 86 CA. So all these points are important for you to remember in the examination. Now let us try to understand the amendments made to the Right to Education Act. Now first is the 2012 amendment, right? This amendment, which was made in the year 2012, right? This amendment, it actually extended the benefits of the act to include children with disabilities. Children with disabilities. It also allowed for home-based education for those who cannot afford due to severe disabilities. At the same time, it is important to note that this 2012 amendment, it exempted the minority educational institution. It exempted the minority educational institutions from certain RTI provisions. Why? So as to protect their autonomy under Article 30 of the Indian Constitution, which also is a fundamental right. So, children with disabilities exemption to the minority education institutions, these changes were brought under the 2012 amendment. Then we have the 2019 amendment. Now, under this amendment, right, this amendment actually removed the no detention policy. No detention policy, which means No detention, you cannot fail a child. But now it removed this provision of no detention policy. Why? Now it gives the state power to hold the students back in classes if they do not perform well academically. The idea was to improve the accountability and also learning outcomes. How? By encouraging better performance among the students. So this was the amendment brought under the 2019 amendment. I hope you understood the Right to Education Act as well. Now, the next topic. The Union Home Ministry recently announced that NGOs involved in activities that may harm national interest, NGOs that may harm national interest, such as forced religious conversions, encouraging protests, or having links to terrorism, can have their FCRA registration cancelled. To understand the context, it is important to understand what exactly is Foreign Contribution Regulation Act. Now let us discuss what is FCRA. Now FCRA, this was originally passed in the year 1976. It was passed in the year 1976 during emergency. Now the purpose of FCRA, Foreign Contribution Regulation Act, was to prevent foreign interference in India's internal affairs, which means the foreign company should not fund an, let's say, independent organization in our country so as to interfere in India's internal affairs. Let's say, for example, I'm running an institution in a country, right? A foreign company pays me money so that I protest against a government policy, which means a foreign company is trying to interfere in India's internal affairs. That's the reason the FCRA was introduced in the year 1976. And then in the year 2010, the original act was passed. Sorry, in the year 2010, the original law, the act was repealed and it was replaced by a more, let's say, stricter or let's say tighter version, which also remains in effect today. Now, talking about the objective, I discussed what exactly is the objective. The main objective of the act was to regulate the foreign donation. Now, so much of foreign donation comes into our country. But do we know the reason why the foreign companies are donating money? Yes, it's not that the donations are done, let's say, in the health sector, in the education sector, but the donation can also be to, let's say, to harm India's national interest, right? And the purpose was also to ensure that they are used in ways that uh, can, right? Which means the donation should not harm India's national interest. Let's say India's internal security, sovereignty, or let's say public interest. This is the objective. So anyone through donations, if they're, let's say, harming India's interest, then the government will take action. Government, which means it is the Ministry of Home Affairs. It is the Ministry of Home Affairs who is the nodal agency. Nodal agency when it comes to enforcing the provisions of the act. Again, an important point for your prelims, that Ministry of Home Affairs. Now, please remember this law, the FCRA, is applicable to all the individuals, associations, and the NGOs that receive foreign contribution. So, individuals, associations, and the NGOs that receive foreign contribution donation, the law is applicable to each of these. Now, the question is, what counts as foreign contribution? Again, this can be asked in the examination. Foreign contribution, which means donations, gifts, or transfers received from a foreign source. Second, Personal gifts are allowed as long as their market value is within a limit specified by the government on the date of receipt. Commercial payment like earnings from foreign clients are not treated as foreign contributions since they are part of regular business. So what is counted, what is not counted? The NRI contributions from personal savings through official banking channels are also not considered. However, if the donor is an Indian origin person who has acquired foreign citizenship, their donation is treated as foreign contribution. Simple. If a relative abroad sends money, it is not treated, right? So when it can be treated, when it cannot be treated. Again, please read once, twice, more than sufficient. This will help you to remember all the points. Now, key provisions. Which are the key provisions? One, mandatory registration. Now, see, the provisions can be asked in the prelims examination as well. So, about the act and two statements, three statements, four statements. So, of the let's say two statements or three statements, how many of these statements are correct? So, such type of questions can be asked. Mandatory registration, NGOs must register under the FCRA to legally receive, which means they have to register under FCRA to receive foreign donations. Initial registration is valid for 5 years and can be renewed if rules are followed. Purpose of contribution, the foreign contributions can only be used for social, educational, religious, cultural or economic activities. Annual returns and compliance. NGOs must file annual returns like income tax filings. They are also required to have a bank account integrated with core banking system. Prohibited funds must not be used to harm India's sovereignty, national unity. Ineligible recipients. Certain individuals are not allowed to receive foreign funds under FCRA. These includes election candidates, journalists, judges, government employees, public servants, political parties. This was clearly defined in the 2020 amendment. So again, each and every provision is important for the examination. Again, it is self-explanatory. So key highlights of the Amendment Act of the year 2020. The amendment explicitly prohibits public servants from receiving foreign contribution. This was also part of the original law. Transfer organizations that receive foreign funds are not allowed to transfer them to any other individual. Again, transfer is not possible. All individuals applying for registration or renewal must provide Aadhaar numbers. So these are some provisions. Again, it's self-explanatory. So you can download the notes and revise it or revise all the provisions under the original act and the Amendment Act of the year 2020. Now, next topic is about the Places of Worship Act 1991. Now we know the recent Sambhal Jama Masjid case has drawn national attention. It follows a pattern seen in other cases like the Gyanvapi and Mathura, where it is claimed that certain mosques were built over pre-existing Hindu temples. So we know that there are many petitions in the court stating that the Muslim religious places were built over existing or let's say pre-existing Hindu temples. Now, in the Sambhal case, the petitioners allege that the mosque was constructed by Mughal emperor after destroying a Hindu temple. But Section 3 of the Places of Worship Act, it clearly prohibits changing the religious character of any place of worship. Section 3 states that once it's a mosque, it will remain a mosque. You cannot change the religious character of a religious place. In November 2024, a district court in Sambhal ordered a survey of the mosque despite the Section 3 of Place of Worship Act preventing such change in religious character. A district court in Sambhal it ordered a survey in the mosque which was actually flying in the face of the Places of Worship Act. Confused? Don't worry. Let us try to understand the basics. First and foremost, what exactly is the Places of Worship Act? What is the purpose of the act? Now see, this act of 1991, which means the act was passed during the Narasimha Rao government. Why? This act was passed as a response to growing communal tensions. These tensions were surrounding the religious places, especially after the Babri Masjid demolition. The main goal, which means there were communal tensions in our country. Why? Because of the religious, let's say religious sites, especially the demolition of Babri Masjid. So the main goal was to prevent the conversion of places of worship from one religion to another, which means a temple will not be converted into mosque, a mosque will not be converted into religion. The purpose was to prevent the conversion of, let's say, one place into another. It ensures that the religious character of such sites is preserved and not altered through, let's say, legal or let's say physical, that is destroying a religious place. So this was the purpose. Now, preservation of religious character. Now, according to section 3, which we discuss in the context, section 3 of the Place of Worship Act, it says that the religious character of any place of worship, religious character of any place of worship must remain as it was on August 15, 1947. Religious character of a place of worship. This means that if a building was a, let's say, temple, mosque, or let's say church or gurudwara on 15th of August 1947, which means it will continue to be recognized as such. It cannot be converted into places of worship of another religion. So, as on 15th August 1947, if it's a mosque, it will remain a mosque, church, church. It won't change. And the law also allows for ban on legal claims for religious conversion, which means the law states or the law prohibits the filing of any new, let's say, cases or lawsuits, the purpose of which being to change the religious character of a place of worship to another. The act also nullifies any such, let's say, pending cases that were filed before August 15, 1947, which means this law states that even law petitions cannot be filed. Forget about converting a place into another religion. A petition cannot be filed in the court. You can file a petition in the court. Forget about changing the religious character. But the law had three exceptions. The law had three exceptions. The law does not apply to the Babri Masjid, Ayodhya Babri Masjid dispute. Why? Because it was already being heard in the court before the act came into force. The case was being heard by the court. That's the reason this was left outside the Places of Worship Act. Right? Then the archaeological sites. Now, places covered under the ancient monuments, right? Especially ancient monuments and archaeological sites act of 1958 are also not governed by this law. Places falling under the archaeological survey act of 1958. Then disputes settled before the act, which means any religious disputes already resolved before the law was passed, or let's say or settled through mutual agreement, again are also exempt. Resolved before the law was passed is also exempt. I hope you understood the provisions of the Places of Worship Act 1991. Right? This brings us to the next topic, which is the Unlawful Activities Prevention Act. Now, what is the context? The Supreme Court recently ruled that 14-day timeline for granting prosecution sanction under the UAPA is mandatory. This means that both the central and the state governments must approve or deny prosecution within this limit. Prosecution is whether to, let's say, start the trial to charge a person with some crime under UAPA. And if this deadline is not followed, it can lead to quashing of the case. The court clarified that the timeline is not flexible, opposing previous rulings by the Bombay and the Jharkhand High Courts. The decision will apply only to future cases, not retrospective, but prospective from future date. It's okay if you're confused. Let us try to understand the basics of UAPA first. What exactly is UAPA? UAPA stands for Unlawful Activities Prevention Act. So here we are trying to prevent the unlawful activities. This act was passed in the year 1967. 1967 and was made. The purpose was to prevent actions that threaten India's sovereignty, India's integrity, India's unity. So this law not only or aims to stop not only unlawful activities but also the terrorist actions and associations involved in those acts. With unlawful activities, this law is also bringing the terrorist actions and people who are involved with such terrorist activities under this fold. So let's say, for example, if you are responsible for, let's say, for funding a terrorist operation, then you will be charged under UAPA. You will be charged under UAPA. Now, under the act, unlawful activities means any act done by a person or a group. The purpose of doing such activities to threaten India's sovereignty or let's say unity. Talking about the key provisions of the UAPA, Section 3. This Section 3, right here under Section 3, the central government has the power to declare any organization as unlawful, especially when it believes that the organization is involved in actions which is threatening India's integrity or India's sovereignty. The central government, who? The central government. Under Section 43D, subclause 5, this section makes it extremely difficult to get bail. Bail is not a rule, bail is an exception. In one of the topics that we are discussing on the bail, in normal cases, bail is a rule, jail is an exception. But here, getting bail itself is very, very difficult. The courts must give the public prosecutor, the one who is charging a person with certain crime under the act, a chance to argue against the bail. And if there are responsible grounds to believe that the charges are true, then the bail will be denied. The bail will be denied. I repeat, if the courts must give the public prosecutor. Who is a public prosecutor? Who is prosecuting against an accused person. So public prosecutor, of course, a person who is accused will file for a bail. So court will give a chance to the public prosecutor to, let's say, to argue against the bail. And the court finds that the public prosecutor has given reasonable grounds to believe that the charges levied against a person is true, then the bail will be denied. Which means it leaves very, very little scope for judicial discretion. And then this law also allows for severe punishment, including, let's say, death penalty or life imprisonment as well. Now, please remember, under UAPA, the investigating agency, be it, let's say, the NI, can take the investigating agencies. They can take up to 180 days. They can take up to 180 days to file a charge sheet. In normal cases, it is 90 days. Within 90 days, the investigating, what is charge sheet? Let's say, for example, the police has accused a person of, let's say, doing a crime. It is only accused. Now the police has to prove that the person has committed a crime, which means the police has to submit evidence. When the police collects evidence, the police submits charge sheet. Charge sheet is nothing but a document with all the evidences mentioned. So here the investigating agencies are getting 180 days to charge file sheet. Under normal cases, it is 90 days. And again, this period of 180 days can be extended with the court's approval, which means if the investigating agencies need more time and if the court understands the circumstances requires the police more time, then here the courts can also allow for extended detention. Now talking about applicability. Now UAPA, it applies to both Indian as well as foreign nationals. Again, a very important point for your prelims. Now it can be used even if the crime is committed outside India. The crime that is committed outside India, and if it is affecting India's interest, crime happening outside India and affecting India's interest, in such case UAP is applicable. UAP is applicable. Now there were two major amendments to the UAP Act. One is in the year 2004 and 2019. See, during the course of this law, two important laws were made. One is the POTA and TADA. Because of the misuse of the provisions of these laws, both Prevention of Terrorist Activities and Terrorist Activities Disruption, Terrorist and Disruption Activities Act. So these two laws were repealed. Why? Because of the misuse of the provisions of these laws, this were repealed. And that's the reason amendments were moved to the original act. For example, in the year 2004, which is before 2004, the act, right? Yeah. Before 2004, the act only dealt with issues like secession or session. Secession, let's say when a part of the country wants to, wants to cut from India. They do not want to be a part of India. Cession, which means giving away a part of India to a foreign nation. So this act before 2004, it act dealt with only issues like secession. For example, the Khalistanis. The Khalistanis are demanding secession, which means they want Punjab to not be a part of India. Or cession when you are giving a part of territory to other country. That's the reason it dealt with only these two issues. Now the 2004 Amendment Act, it added Terrorist Act. Even the word Terrorist Act was included in the 2004, that is in the list of offences. Now the 2004 amendment actually allowed the government to ban the organization for being involved in terrorism. This was in the year 2004, and the next major amendment came in the year 2019. Now the amendment, it gave more powers to the government. How? First, it allows the Home Ministry to declare even individuals along with organizations, even individuals can be designated as terrorists under the 2019 Amendment Act. And then the 2019 amendment, it gave the NIA, National Investigation Agency, the authority to seize properties which are related to terrorism and conduct investigation without the state government approval. So any activity that is prejudicial, that is threatening India's integrity, sovereignty, the NIA does not require any state government's permission, can simply conduct investigation. And then this amendment also included nuclear terrorism. Nuclear terrorism under UAP. Under UAPA. So these are the major amendments and the provisions under these two amendments. I hope you understood the purpose of these two amendments. So, Madhu, can you repeat your question? What exactly do you mean? Let me know if you have any questions, doubt. Okay. The next question, context being the Post Office Act 2023 has come into force. This act has come into force, replacing the outdated Indian Post Office Act of 1898, which was in effect for 125 years. The act, which was framed before India got independence, was continued for 125 years until 2023, when India replaced this law of 1898 with the Post Office Act of 2023. Now, let us try to understand the purpose of the new act. This Post Office Act of 2023, the purpose is to modernize India's postal services. What is the purpose? To modernize India's postal services. It is designed to improve citizen services, especially with respect to boosting, let's say, postal banking operations, and most importantly, to make the lives of people easier. How? So that people can easily access the government schemes. How? By modernizing India's postal services. And the focus is on transparency, efficiency, and most important, accountability. Now, talking about the key features of the act, right? Key features. First one is the power to intercept postal items. Power to intercept postal items. Now, under this power, the central government now has the power to intercept. Yesterday we discussed the interpretation of intercept. Who has the power? The central government has the power to intercept, or let's say open, the postal items. This can also be handed over to the customs if necessary. Who has the power? It is the central government that has the power. Now, under the act, the central government can allow officials to, let's say, carry out interception on important grounds like national security, foreign relations, public order, emergency, or let's say public safety. Again, it is the central government, and the post office officials can also check items which are suspected of carrying prohibited items like drugs that should have been, let's say, declared to the custom officials. So again, here you see the central government has a power to intercept. They can also check the postal items, the items that you courier from one place to other. If the postal officials have suspect, they have the power to check the items as well. One. Second, legal precedence examples in the original act. Now earlier, right, in the 1898 act, right, it banned the mailing of harmful or, let's say, dangerous items. It banned the mailing, that is transfer of harmful or dangerous items. Now again, under the new law, it allows the government interception of postal items, let's say, in emergencies, or let's say for safety reasons. And again, the power is given to the central government. Exemption from legal liability, which means as per the new act, the post office and the officials, the employees of post office, are not legally responsible for any loss, any delay, any damage, or let's say misdelivery. So the post office employees, they are exempt from any legal liability. Then we have the end of penalties for postal staff misconduct, which means the 2023 Act, it removes specific penalties, let's say of fraud, theft, and misconduct by postal officials. And this such type of frauds and penalties were mentioned in the 1890 old Act, but now the new law has removed all such, let's say, specific penalties. Recovery of charges, which means that the new law, if someone fails to pay postal charges, then the unpaid amount can now be recovered like, let's say, the land revenue dues. So if someone is failing to pay postal charges, the unpaid amount can now be recovered. This is what you need to remember. So again, here, if a question has to be asked, question will be asked with respect to, power to intercept postal items. Who has the power? The central government has the power, right? Again, penalties, which means the post office officials are exempt from legal liability. They have the power to intercept, right? So here, these are the few things that you need to remember for your examination. And then end of government monopoly in the postal services. Now, please remember that earlier in the 1898 Act, it gave the central government power, or it gave the central government exclusive rights to deliver letters. And this section or this provision has been removed. Now, the private couriers, the services, they used to avoid this law. How? By using the terms like documents or parcels instead of letters. The right was exclusively with the central government to deliver the letters. So they just changed the terminology, which means they took advantage of the loophole in the law so as to, let's say, be engaged in the postal service. Now they can operate without any confusion, which means now the private people have also been given power to, let's say, deliver emails or letters or whatever it is. Power of the Director General. Now, the Director General, not police, the Director General of the Postal Services, the DGPS, has been given the authority to regulate the time and manner of postal deliveries under the new law. So, he has been given the power, right? What? To regulate the terms and, let's say, the time and the manner in which the postal deliveries are to be made. Then concerns from the 1338 Law Commission report. Now, what are the concerns the 38 Law Commission has reported? Now, which are the concerns? One, see, the Law Commission had earlier raised concerns that the old Act of 1898 allowed broad and unclear reasons for intercepting mail, which could actually violate the right to privacy, especially after the 27 Putta Swamy judgment. And as a reason, these concerns led to reforms in the interception laws, such as the Telegraph Act of the year 1981, which we discussed yesterday. The purpose of which was to limit the executive powers and protect the privacy. So these are the concerns highlighted by the 38th Law Commission. And this brings us to the end of the last topic under the theme Important Acts, Bills and Important Guidelines. Right? I hope you understood each and every topic that we have discussed under the new dimension. Make sure you are downloading the notes of the topics that we have discussed so as to revise and make sure you remember each and every important point that we have discussed in the class. Students, now let us start with the new theme, right? So let me just open the new theme, okay? So maybe another 2 to 3 days and we should be in a position to complete all the topics, close to 110 topics under the different themes. Again, make sure you're downloading the notes from the link given in the description box, and make sure you're revising each and every topic that we discuss. And before I call it, or before I wrap the session, please make sure to spread the word as much as possible. Get all the serious aspirants on our channel, like the videos, subscribe to the channel, and again, spread the word to as many aspirants as possible. On this note, I'll call it a wrap. Thank you so much for watching.